Welcome. Thank you for joining the ABA Forum on Construction Laws uh, Division 5 General Contractors Nuts and Bolts series. This is the second installment of our series on foundational topics in construction law. Um, if you are not a member of the forum, this is your plug to consider joining the Forum on Construction Law. It is the largest group of construction lawyers in North America, and I've heard the world, although I can't necessarily verify that. It has been, I joined about 3 years ago, and it's been a tremendous, warm, welcoming community. Um, if you do join the forum, or if you are a member and you're not a member of Division 5 General Contractors, uh, we ask that you consider joining Division 5. We are an active division. We try to have fun at our social events, the national meetings, and try to have lively hot topics calls once a month. Our next hot topics call is on Tuesday, June 16th at 5 p.m. Eastern, 2 p.m. Pacific. Um, that will be on how alignment of complex data drives better project outcomes and stronger claims, presented by Kelly Bishop and Chris Boyd of Secretariat. Um, for the Nuts and Bolts series that Division 5 is putting on, our next installment of that will be on Thursday, July 16th at 1 p.m. That will be part two of HKA's foundational series on delay and disruption claims, continuation of the discussion we began earlier this year. Um, if you've registered, all of you have registered for this, we'll make sure to send out registration information for that to all of you. The forum's next annual meeting is in Boston, the fall meeting, October 21st to 23rd. So if you are involved in the forum, if you come to our meetings, I look forward to seeing you in Boston. Um, if if you're considering joining the forum, that would be the next opportunity to join all of us at a national meeting. Um, my name is Saket Khan. I am an attorney in Needham, Massachusetts. I practice construction law, and I'm involved in Division 5 general contractors. Um, with us here today is Will Bennett. Will is an attorney at Saxe, Doerneger, and Vita. He is out of their Temecula, California office. Um, Saxe is one of the nation's leading firms in insurance coverage issues. Will maintains an active litigation practice focused on complex insurance recovery actions across the country. He also advises on insurance issues um, more generally, and everyone I've heard talk about Will says he is a go-to point person on all things construction insurance. So we are very lucky to have Will um, give us an overview today. Uh, I will be monitoring the chat for questions, and so please feel free to put any questions you have in the chat, and we'll raise them as we go. Thank you, Will.
Yeah, thanks for that introduction, Sakib. Looking forward to doing this. I love doing versions of this presentation with construction lawyers because you guys tend to know a lot of the fundamentals, but then also tend to enjoy some of the takeaways when we get into a little bit more of the nuance. Yeah, so just a little bit of background on me very briefly. I've been doing this for coming up on 15 years now, which is the duration of my career as a lawyer. I've been an insurance coverage lawyer the whole time, and the majority of my work the whole time has been construction industry, a little bit of real estate, but mostly general contractors. And so I very much bias towards the lens of how the general contractor sees these issues, which normally I have to sort of, disclose and talk about how that's my bias and all that. But I guess in D5, in the general contractor group, that's just a given, which is nice. So very much going to be attacking and thinking about this stuff from the general contractor's perspective. I'm going to do, oh, hold on. There we go. I'm going to talk about construction insurance issues generally, and that's going to take me across a variety of policies. But I'm going to spend the majority of my time in three particular lines of coverage, and that's going to be the CGL policy, which is probably the one most of you are the most familiar with. and it's one of the easier ones to navigate, but it also does have some nuances and some things built into it that I think are commonly misunderstood, even amongst people who have a pretty good handle on it. I'm going to talk about builder's risk, which is, I would say, very familiar to the construction lawyer contingent, but also I find that the group tends to find it a little bit daunting, which makes sense because it's a significantly more customized policy, less consistent than the CGL is across jurisdictions. And then I'm going to hit a little bit of pollution and a good amount of professional liability because those are two that come up pretty frequently on construction disputes, and have some complexities and significant pitfalls that get stepped into more often than they should. But it is also important to keep in mind that construction companies are not different than any other companies, in that they still have a baseline set of coverages that apply to them just as they apply to a tech company or a manufacturer. So the risks, this is sort of a breakdown here on this slide of kind of how the risks fall in buckets in the way I think about things. You've got course of construction risks, course of construction liability risks as well. So that's going to be your, injury claims, injuries to workers, injuries to third parties, as well as your course of construction damage to the project, and how you would deal with that. And that's gonna really incorporate all of the lines of coverage I just mentioned. You have your post-completion risks, which are your construction defect claims primarily. Topical risks is what I'm going to call them, and I call them that because I think of them as derivatives of exclusions from the CGL policy. When you think about the CGL policy, you've got a very broad coverage that's then carved back through all sorts of topical exclusions. The two most prominent of those that themselves then give rise to their own unique policies are pollution and professional. So the pollution exclusion obviously coming into play in the late 80s gives rise to pollution liability policies coming up in the 90s. And then professional exclusions almost always endorsed onto CGL policies, which gives rise to your professional liability coverage being distinct. And then the normal commercial risks I mentioned, employment comp, there's other auto, things like that. With CGL, I think it's valuable to just start with the fundamentals because I think the fundamentals are somewhat understood, but in turn also somewhat misunderstood. So I like to start with just the basic insuring agreement of the CGL policy. So the policy is effectively covering the insured's damages because of bodily injury or property damage to which the insurance applies. All right. And that seems really basic. Probably everybody generally understands that that's the insuring agreement of the CGL policy. I want to hone in on two words, though, because I think they're not appreciated for what they actually say as much as they should be. And that's because of. And so I'll hear people say things like, oh, well, I don't think CGL covers liquidated damages, or I don't think CGL covers consequential damages. It only covers the property damage. That is not the case. There is really good case law across the country that treats because of those two words as very expansive and actually encompassing all those things I just mentioned. And you can use that because of language in a very flexible way to find coverage for costs that are not the intuitive costs you think of when you think of what a CGL policy covers. Example. So I did some work with the owner of the Hard Rock Hotel that collapsed in New Orleans back in 2019, the end of 2019. And in the immediate aftermath of that, the costs, when you're in a catastrophic loss situation like that, the costs that accompany that are not the natural costs that you're accustomed to dealing with in a claim that's insured by CGL. You've got, complex evidentiary preservation protocols you have to deal with, heavy security requirements for the site, for the warehouse where the evidence winds up, traffic control costs, all sorts of things that, I wouldn't customarily think of as being part of the CGL's insuring grant. But when you dig into the case law, that because of language gives you a lot of room for argument. And ultimately, we were very successful in getting really all of those sorts of random seeming costs insured through that because of language. So that's something to keep in mind for sure. The other place I like to go in the insuring agreement is I said before, this covers legally damages you're legally obligated to pay because of bodily injury or property damage to which this insurance applies. And so the section B of the insuring agreement tells you this is when it applies. This insurance applies to bodily injury or property damage only if you meet some conditions. A couple of them are easy. Coverage territories is usually going to be the US. But the two I want to hone in on are bodily injury or property damage is caused by an occurrence. Okay, that's one. So what is an occurrence becomes a question there. And two, the bodily injury or property damage occurs during the policy period. So one misconception I want to nip in the bud right up front here. A lot of people are accustomed to saying, oh, it's occurrence-based coverage. That means we're going to look at when the occurrence happened. What did I just say though when I read the words? The bodily injury or property damage is caused by an occurrence, and the bodily injury or property damage occurs during the policy period. So I hate that the Insurance Services Office, ISO, that creates this form used the word occurs in paragraph 2 there because it sounds a lot like occurrence, but it's not the same thing. The occurrence is your accident. It's your creation of a defect. It's your, ladder falling over that causes somebody to get hurt. It's your maybe exposure to a toxic chemical. That is not the measure of which policy we're looking to find coverage. So remember, you've got a policy being placed every year consecutively, assuming we're not in a wrap-up. Policy placed on an annual basis every year. Paragraph 2 here is telling you that the policy you need to look to is the policy when the bodily injury or the property damage occurred, not when the occurrence occurred. And that's critical because you might have, it gets really interesting in defect world where you install a defective pipe. The pipe now trickles across 5 years and eventually the damage is realized and, has to be fixed. And so then the question pops up, which policy do you look to for coverage? And the question becomes, which policy did property damage occur in? And that's not a straightforward question at all when it's occurring across multiple periods in a, sort of a latent way. And, courts take that all kinds of different directions. Some of them look at when the property damage started. Some of them look at every year in which the dripping's happening. Some of them look at the year when it becomes apparent to the owner of the building. But the point is, the question that you need to answer is, or need to try to find the answer to, is when the property damage occurred, not when the defect was created, the injury first happened, that kind of thing. Okay. The meaning of occurrence also generates a bucket of issues in construction world. I would say when I started my career 10, 15 years ago, back in that range, maybe even as recently as 5 years ago, the whether construction defect constitutes an occurrence issue was a very, very hot issue. There were still quite a few states that hadn't addressed that issue and didn't have answers to that question. That has become more clearly resolved at this point. Basically, the issue is this. So you have a policy that insures against effectively accidents. That's what the meaning of occurrence is. An accident including continuous or repeated exposure to substantially the same general harmful conditions. And then the court is asked to decide whether a contractor who has done work improperly has done something that is accidental. And the courts got into this long, twisted discussion about whether, that's really just the nature of their work, a business risk that they assumed, or is that truly fortuitous and something that we're accustomed to trying to insure? For the most part, a pretty substantial majority, the courts landed on um, the damage that results from defective work is covered property damage caused by an occurrence. The defective work itself is not property damage caused by an occurrence. So basically, the contractor sort of assumes the risk is not, it's not fortuitous if the contractor does something wrong, but to the extent that then damages other work, um, that's going to be covered. So that's really the primary, and I think I actually maybe jumped myself and there's another slide on this, but I'll be able to go through that one quickly now. I think that's the primary occurrence. Is there an occurrence issue that pops up in the construction world? Um, just quickly here, bodily injury. This is a definition that's often modified to include um, emotional distress and things like that, but usually you're going to need some sort of a physical manifestation. So whatever the claimed injury that you're hoping to get coverage for is, always want to be looking for some kind of a physical manifestation, which can be extended as far as, the plaintiff having trouble sleeping, things like that. There's courts that have given coverage for bodily injury in those scenarios, but some sort of physical thing, not just, I'm struggling emotionally from what happened to me. Um, the meaning of property damage is another one to spend a moment on here. So there's the obvious first prong that I think everybody thinks of intuitively when they think of what is property damage, and that's physical injury to tangible property, including the associated loss of use. Okay. I accidentally knock a pipe out and cause a spill. I've clearly physically damaged, or physically injured tangible property. The one that's less commonly considered is the second prong, the loss of use to tangible property that is not physically injured. All such loss of use being deemed to occur at the time of the occurrence that caused it. So that one doesn't come into play a ton, but it sort of sneaks its way in sometimes into consideration in circumstances where it feels like there's something that should be covered, but there's not an obvious source of property damage. The thing that you have to watch out for then is there's a corresponding exclusion. It's exclusion M typically in the policy, M as in Mary, and that's the impaired property exclusion, which taken in a vacuum, you could read this loss of use of tangible property not physically injured to get you um, property damage for that situation I was talking about before, like just defective work itself. Impaired property kind of helps to shore that off. So usually it's going to be 17A that you're dealing with in a construction situation, but just be aware of 17B if you're struggling to figure out where the property damage is, and then always evaluate that in conjunction with exclusion M, which is impaired property.
Will you have any examples or hypotheticals as to what type of damage might thread the needle between that exclusion and this coverage? Or
As I was starting to say it, I was like, oh God, somebody's going to ask for an example here. Um, I could dig up a couple examples, I'm sure. Off the top of my head, I'm going to struggle. And I was realizing as I was saying it that I was struggling to think of one. Uh, but if anybody who asked that question wants to reach out to me, I will run back through times when I've used it and come up with something for you. And here's the slide that I skipped myself on earlier. So I will elaborate on it a little bit though. So the defective construction constituting an occurrence, which is really a question of whether defective construction constitutes property damage caused by an occurrence, breaks down ultimately in the case law to really three buckets. And that's the faulty work itself, which I mentioned is generally going to be deemed not covered no matter where you go. The cost to just, let's use the pipe example. Pipe is installed defectively, breaks behind a wall, and there's water gushing out, right? So the cost to go in and fix that pipe in pretty much every jurisdiction is not going to be covered. The damage that that water causes to all the other work throughout the building generally is going to be covered. That's going to be deemed property damage caused by an occurrence. The question that's the least resolved is actually largely unresolved still in the case law is what you do about the hybrid of those, the rip and tear, which is if you have to rip out undamaged work to get to covered resulting damage, what do you do with that cost? And that gets called rip and tear. Colorado was the first state to say, yes, we're going to cover that. I think they've actually maybe even codified that at this point. But there's really only a handful of states that have any law at all, and it's mixed. Um, I do find, just sort of as a practical aside, I do find a decent amount of reception from insurers to giving consideration for those rip and tear costs at mediation on, construction defect claims, even in states where there's no case law or not the greatest case law, California being one of those. Um, so in it, so that's all scope of coverage. What does the policy cover? The other piece of CGL coverage in construction is the risk transfer component. So there's the policy issues tied to what does this policy cover? And then there's the policy issues tied to does this risk transfer effectively from me to this other party's insurance policy? And so your goal is everything flows downstream, right? Everything goes from the top of this chart to the bottom of this chart. All risk goes downhill. And that's usually going to be manifested if everything was done right in contracts as the landowner, bank requiring that the project owner, the GCCM, the primes, the subs, the sub-subs, everybody provide additional insured coverage up to them on their respective policies, up to that landowner bank, for any liability, usually caused in whole or in part by the party whose policy we're talking about. And then the owner is going to do the same thing, requiring that downstream. And then the GC is going to do the same thing. And um, the risk, aside from the exposure risk that we're trying to transfer, the risk transfer risk that we run into is every single one of those policies that all those parties have, assuming even that they get what they're supposed to get, which is going to be probably a CG 2010 additional insured endorsement with language that says anybody required by written contract is an additional insured. Even assuming that they've all gone out and gotten the right policy language and the right additional insured forms, every single one of those contracts, all the way down that chain, has to have actually required it properly. Uh, and so this illustration and imagining, I don't know if you can see my mouse, but like maybe do I have a laser? I've got a laser pointer. Imagining every one of these junctures being an opportunity for that contract to get screwed up. There's all the advertisement you've ever needed for why wrap-ups are helpful, right? As if you didn't already know that, and I'm sure you all do. But that was the derivative origin problem for why wrap-ups came about. That and cost, obviously. Um, and so that additional insured coverage this is the illustration of sort of what's happening there. You've got your upstream party, let's say a GC for the sake of this group, and your downstream party, let's say a sub. The GC's got two ways to pass that risk down to the subcontractor. One is indirect and relies on, well, sorry, I should say two ways to pass the risk. One is direct to the downstream party, to the sub, but it relies on the subcontractor, having a balance sheet that can handle that exposure, or itself being properly insured to protect itself against that contractual exposure. That's the contractual indemnity claim. The advantage of the additional insured coverage, it's pretty 101, you're probably preaching to the choir here, is the direct access to that policy, right? The subcontractor is probably insured for its contractual indemnity obligation to you. But if any of you have had comparable levels of success to me in trying to get subcontractors to pick up contractual indemnity tenders, then you've probably been pretty frustrated by that also. So that additional insured coverage is critical access to protection directly. Sort of overview here of just what we're talking about in that indemnity versus additional insured world. They're independent obligations, obviously. Again, I mentioned that subcontractor is probably insured for that obligation, that contractual indemnity obligation. That's through an exception to that contractual liability exclusion in the policy. So it's important that when you're doing your subcontractor insurance exhibits and things like that, that you're making sure that there's an obligation that they not have that modified. A lot of insurers will try to sneak modifications to that exception in, modifications to the definition of insured contract, for example, that change the scope of what coverage the sub has for that contractual indemnity obligation. And then there's a whole host of issues tied to additional insured coverage that I could do 2 hours on by itself. I'm not going to. But generally speaking, the biggest issues to be watching out for are privity and exclusions built into those additional insured endorsements themselves. So privity is the idea that the AI coverage only applies or somebody is only an additional insured if or with respect to the party with whom they contracted with. So the AI endorsement will say, the person's an AI if you contracted with that person to provide that coverage. And what you really want is just anybody required by contract, because let's say you're talking about the subcontractor going out and getting coverage from its sub-sub, and then the sub-sub is the one who creates the issue. If it says only the parties with whom you contracted, then that sub-sub only directly contracted with the sub. And so you as the GC are not entitled to that additional insured coverage, even if the sub went through the step of requiring the sub-sub to protect you as an additional insured, because the contract language is not going to override the policy language in that situation. And then built-in exclusions, when you start to get away from the standard additional insured forms and you get into the carrier-specific ones, especially from the carriers that tend to insure the lower level subcontractor markets, those exclusions tend to have, those additional insured endorsements tend to have exclusions baked into them that aren't usually in the forms. So watch out for that. So I'll shift to builder's risk. Builder's risk, so whereas CGL is insuring liability and is therefore a third-party coverage insuring against risks from third parties, the builder's risk is a first-party coverage. It's you having coverage directly for your project and the damage that happens to it during the course of construction. The daunting part about builder's risk is that it is completely non-standard. There are consistencies, for sure, common terminology sometimes, but the structure and the form of those policies varies from insurer to insurer with almost no direct consistency. And so that makes it unpredictable, and more than any other policy requires you to get in there and really evaluate the relevant wording before submitting a claim, ideally. And I'll talk about that a little bit. But again, I'll start just up front with the insuring agreement. There's two primary types of insuring agreements in builder's risk world. This also carries over to commercial property if you do any real estate stuff. By far, the all risks is going to be the preferred insuring agreement, and I'll talk about why here. So builder's risk, all risk insuring agreement is very, very broad. The policy insures against all risks of direct physical loss or damage to insured property while at the location of the insured project, or offsite temporary storage or in transit. So that's, again, nothing standard, but that's pretty close to what you'll find in any all risks builder's risk policy. The alternative is specified perils. We'll pay for direct physical loss or damage to covered property caused by or resulting from any covered cause of loss. And then the question becomes obviously what's a covered cause of loss, and there's a defined term there. And this is where I don't understand why they do this. Many times it'll say this in the insuring agreement, and then the covered cause of loss will be defined as exactly what I read in the first one, all risks of direct physical loss or damage, which inevitably makes me just smack my head against a wall. Like, why didn't you just use an all risks insuring agreement? But sometimes they define covered cause of loss to mean 12 specific perils: fire, earthquake, flood, whatever. The problem there, yeah, it's probably true that most of your losses are going to fall within those 12 perils. And, some are not, and maybe the client's even comfortable with the idea that, other perils outside of those perils are not insured. Fine. The real problem is this: when you have an insurance dispute, in I think every jurisdiction, I haven't actually evaluated this in every jurisdiction, but I've never seen an exception to this. The initial burden of proof in that dispute is on the policyholder. The policyholder has to establish that the loss triggers the insuring agreement of the policy. If your insuring agreement is all risks of direct physical loss or damage, your only burden of proof to start this claim off is to show that you had physical loss or damage to your project. The insurer then has the burden to go through and try to find a reason why it's excluded. If you have a covered cause of loss, specified peril policy, and there's only 12 specified, covered causes of loss, it is now your burden as the policyholder to prove that the loss was caused by this specific thing. So they have effectively shifted the burden of proof from themselves to prove that an exclusion applies to you as the general contractor, the insured, to show that the loss was caused by something specific. So it's a more significant thing than what it appears to be on its face. Couple quick hits here. So as I said already, generally the insuring agreement's really broad, all risks of direct physical loss or damage. And the question then becomes, okay, so it insures against all risks of direct physical loss or damage. What is it going to pay me for that? And the answer is you turn to the valuation provision. The valuation provision is typically going to say something relatively similar to what this says, which is, the important parts: the cost to repair or replace the property at the time and place of loss, material of like kind and quality, less betterment, including contractors' profit and overhead, and including owner's indirect expenses to the extent declared. That language becomes the subject of quite a bit of fighting, quite a bit of dispute. And I'll get into a little bit more in a minute, but things like general conditions, which tend to be a big bucket of costs in a lot of big construction claims, the policy is probably not ever going to use the word general conditions. And so you're going to be tasked with trying to figure out, okay, where in this policy do I fit this? I get into some of the other coverages like the delay coverage, but sometimes you have to get very kind of minute with the project team and work to understand the nature of a particular type of cost, and then try to find what aspect of this policy best describes something of that nature, rather than having the guidance of a policy provision that just says general conditions are covered here. Um, Typically, there is an exclusion for consequential loss. The this, though, itself becomes controversial because I don't know how they still make this mistake, but the exclusion section will typically say we don't pay for loss, damage, expense caused by one of the following perils. And then they'll say right out of the gate, often consequential loss, as though consequential loss is itself a peril, like fire or rain or something. Consequential loss is very much a result of a peril in our language scrutinizing policyholder insurance opinion. So we wind up in a lot of fights over whether, especially with delay costs and general conditions often falls into that fight, whether this consequential loss delay exclusion applies as a applies to those types of costs that result from something covered, as opposed to whether the exclusion is only dealing with those as a peril themselves. Two coverage, there's a lot of coverage extensions available under builder's risk. Two of the most frequently called upon ones in the construction world, well, I guess all builder's risk is construction world. Two of the most frequently called upon ones are extra expense and expediting expense. And effectively they are extra expense for extra costs incurred to try to keep the undamaged scope of work flowing while the damaged stuff is being fixed. Example from a claim I had not that long ago, there was a large, significant need for temporary power after water loss knocked out the permanent power that had been installed for a while. That temporary power cost was an extra expense cost. Expediting expense is basically costs incurred over and above the normal cost of work to expedite the repair to try to get the thing back on to recover the critical path, basically. And that could be overtime. I've seen expedited manufacturing and shipping costs to get critical custom equipment to the project, that kind of thing. Uh, Faulty work design and materials exclusions are a huge source of dispute in builder's risk claims. Uh, this slide, I've used this slide before. It used to say leg one, leg two, leg three, but I haven't seen a leg one exclusion in 10 years, and I pretty much always see this modified leg two or cost of making goods, so I've replaced it. I will, though, still talk about leg one. So the leg refers to the London Engineering Group, and they're the group that were responsible for the development of the most standard forms of faulty work exclusions in builders' risk policies, albeit unintentionally. They never intended it for it to be in American builders' risk policies and probably should never have been, but nevertheless, they're here. They're the most commonly used measures for determining the scope of a builder's risk faulty work exclusion, and they're poorly written. So leg one was the just defective work, no coverage for ensuing loss, the go pound sand endorsement. Leg two, traditionally and in its true form, is no coverage for faulty work, but if there's damage that results from that faulty work, we cover it, very much like that CGL framework I mentioned. And then leg three was no coverage for faulty work, except if damage does result, then we will cover the cost of fixing the faulty work itself as well. I should put these up. Modified leg two, which is the most common these days, and COMG refers to cost of making good, which is an acronym developed by Chubb and what they usually title their endorsements and their policies. That's kind of a hybrid of the leg exclusions and an adaptation from commercial property policies, which had a less favorable version of faulty work exclusions. And it's basically this: no faulty work, but if there's ensuing loss, then if there is an intervening covered cause of loss Said that wrong. No faulty work, but if there's, this is written wrong, so disregard what I wrote here. Sorry. No faulty work, but if there is an intervening covered cause of loss that results from the faulty work, then we cover the loss that ensues from that. And so what does that mean? If the contractor does a bad job waterproofing a building and water gets in and causes damage, whereas leg two and leg three would have covered that damage, modified leg two and cost of making good don't. Modified leg two and cost of making good require that that water that gets into the building then do something else, like cause an electrical fire, which is itself covered as a covered cause of loss. And then that's covered, the damage from that. So we try everything we can possibly try to avoid those winding up in our clients' policies, but that is by far the most common version of the exclusion in the market, especially in the domestic market. You typically have to go to the London markets to get something closer to those other two original leg two and leg three versions. But as you can imagine, that's a very significant difference in the scope of coverage available during the course of the project. The builder's risk policy also covers delay in completion, but this is an owner coverage typically. There's a couple exceptions to that, and actually one of those exceptions is maybe the policy that I used as an example here, because Zurich is the sort of the founder of this alternative. But as a default, the delay in completion coverage, which covers lost earnings, lost rental income, and owner soft costs, as a default, that's a coverage only available to the owner. Um, there is product on the market now where the contractor can also get coverage for those costs. But when I said that we fight a lot about general conditions and where those fit, it's because general conditions, right? You're getting a standard amount of general conditions under the contract for the duration of the project, and that number only goes up if the project is delayed or goes on longer, which intuitively makes the insurer claim that it's a delay in completion cost. It's only a cost that results because of delay, except that you can also think of that cost in terms of what it is actually doing, which is in many cases supporting a repair effort, in which case it starts to sound more like that valuation provision, the cost to repair or replace damaged property. But we have that fight a lot. Some insurers like Zurich have sort of tried to solve it by putting a sublimited coverage in the delay and completion endorsement that's available to the contractor, but many haven't, and so that fight still happens frequently. And that coverage has to be attributable to a delay in completion, which is really just something happened, the project completing after the scheduled expected completion date. Terminology is critical in builder's risk world, and especially in the submission of the claim. I say this because every single one of these I've seen submitted as the thing on the left and ultimately wind up actually fitting as part of the cost of repair or replace. I just talked about general conditions and delay. I had a client, E&R 10 contractor, who went out and were primarily thinking about their fight with the owner over a late stage loss on the project that caused the project to go 3 months over. They were primarily thinking about that owner fight, all the disputes they had there. They got a report that said, we have millions of dollars of extended general conditions. They're delaying completion damages. They're delaying completion damages, delaying completion this, delaying completion that. Come to find out that the builder's risk policy said, well, that's nice. We only give delay and completion damages to the owner. That coverage is an owner coverage, so you can't get that. And then as we got into it, we said, what are these costs? And these costs were just general conditions supporting the repair effort. 3 months of going in and fixing water damage, right? That's very arguably cost to repair or replace. And we got a lot of money out of that claim. Even though initially even though we had to spend the entire claim arguing with the insurer why our own report that said that the damages were exactly the thing that they don't cover were not the thing that they don't cover. So you can solve a lot of those problems by looking carefully at your coverage and characterizing properly from the start.
Yeah. Will, before we move much further on builder's risk, couple questions from the chat. One is, how would you know when reviewing the policy which leg coverage you have?
Yeah, so you just have to read the faulty work exclusion, and you can't just read the title because these carriers will put the title leg 3 on it and then it'll be modified leg 2. You have to actually read it and just basically try to understand what it's doing. If it's giving you um, damage resulting from faulty work directly, you're good. If it's giving you, only damage resulting from an intervening covered cause of loss that results from faulty work, you're less good. Um, that usually the first part of the exclusion is going to be roughly the same. We don't cover faulty work design materials. And then where you're going to find the distinctions is going to be in the exception, which follows the main exclusion language. So usually that exception is where you're going to figure that out.
Okay, and then a faulty work question. I'll read it. I think the fact pattern here might elucidate some of the connections between these concepts as well. Faulty work installing knee walls slash light bollards. When the sub ripped out and redid these items, there was damage to the roof membrane. I think, a general contractor is arguing that the roof membrane was resulting damage. So kind of like a rip and tear type concept, whether intentional or not, and should be covered. Would that come under, is that question of intentionality as to or necessity as to whether that's really cost repair replace or if that's
Yeah,
on the sub or how do you parse those types of concepts?
that's a tough one. Because the rip and tear situation is tough in builder's risk because the carrier is going to want to say, all right, so they're going to want to know what is the peril that I'm insuring against. That's what the question they're going to be asking is. And so let's say the first scope of work was done wrong. All right, well, they're not going to cover the cost to just go in and fix the work that was done wrong. We know that. But if damage results, so if we're in a true leg 2 world, if damage results, then that's covered. And so the sub goes in to fix its own work and causes other damage. That itself raises an interesting question. Is that damage that they've now caused the result of the initial faulty work, or is the faulty repair of their own faulty work that causes other damage now a separate peril to be measured as to whether it's faulty work itself? Um, I don't know that I don't have a clean answer to that one.
Mhm.
I don't think, I think you could expect that the carrier would probably fight you on that one. But you'd have some things to say, and you might probably would be living in a world without very clear guidance on that question.
Thank you.
Yeah.
And we're coming pretty close to the home stretch here,
Yeah.
as well. Yeah.
Okay. I will got a couple less critical builders risk slides. I'll just jump to professional. All right. So if you haven't spent time dealing with contractors, professional, and protective, this is some of my favorite coverage because it's so flexible. And the flexibility comes from largely this right here, which is the definition of professional services. And this is a lot of professional policies are not really modifiable, not significantly modifiable, but you can absolutely push for a very broad meaning of professional services. And so some things, that you would see show up as constituting professional services, construction management, project management, program management, all these things on the left here. I've seen as broad as your contracting, your operations as a construction contractor. I've seen that included. And so then the insuring agreement, which is basically any liability from your acts or omissions in the course and scope of your professional services. Okay, cover any liability from your acts or omissions in the course of your operations as a construction contractor. That's really broad and really helpful when you're dealing with claims, especially the ones that don't involve clear property damage. When you've got big defects that are not leaking, not, cracking, whatever. They're just there and they have to be fixed, like a code compliance issue or something like that. Really, really helpful in those situations. But really, really rigid with their timing requirements. So whereas those CGL policies, you can go back to whatever policy the property damage or the bodily injury occurred in, and you can rely on it being there years later. With professional, you get one policy period for everything to happen, and then that policy is gone. So that claim has to be made and reported in the same policy period. And the policy does not care if you have 3 days left in that policy period when the claim is made, or if you have 300 days left in that policy period when the claim is made. If that claim is made against you on December 28th and you don't report it by January 1st, and that's your renewal date, sorry, you're probably out of luck and not getting coverage under that policy. On top of that, it has an exclusion typically for prior knowledge, which can be charged down as far as routine members of the project team. So if that person on the project had knowledge of something that they should have reasonably suspected might give rise to a claim in the future, and that claim doesn't get made and reported until a following policy period, not going to have coverage for it. The good news is these policies are very generous in their acceptance of notice of circumstances. So to avoid that prior knowledge situation, and I actually, this is one of my favorite presentations to do, is go around to my general contractors and have them bring their project team people in and understand what types of circumstances they need to be telling their risk team about so that they can be reported, because they might later give rise to a claim. If you just report that there are circumstances that could give rise to a claim, you lock in that policy. Your reporting is good. If a claim is made 10 years later, you get to go back to that policy and make a claim there. And whereas a lot of other coverages, if you report, they're gonna treat that unfavorably in your renewal. I'm told by brokers that I work with that the professional coverage is very forgiving. It expects that lots of notice will be given liberally, because of that structure. The other important thing to remember with claims made, professional coverage, all professional coverage, claim is typically defined to mean a written demand at a minute. That's like the bottom of what constitutes a claim. So even if the owner writes an email saying, I need you to fix this, that's a claim. If that does, the project teams tend to want to resolve things at the project level. They want to avoid conflict. They want to avoid insurance getting involved, avoid risk and legal getting involved. And so their inclination is to just go fix it. Well, when they fix it and the change order doesn't get approved and we turn into a protracted owner contractor dispute, and 7 months down the road, they're telling risk and legal about it. Maybe you're already renewed and you're already out of luck on professional coverage. And I see that happen constantly. So if you have a claim and you're trying to figure out what insurance might apply, immediately ask the question, is there a professional angle to this? And it's probably a broader angle than you were anticipating. You might say your operations as a construction contractor. Look at what caused the loss. Is there sequencing involved, or project management somehow that you could twist it into being a project management or a construction management issue? All of these insurance concepts are very favorable to the policyholder. So if you can articulate even a tenuous argument, there's a good shot that it'll at least get you some consideration at the settlement table. But only if you're being really diligent about making sure that the reporting is happening on time, because that coverage can just disappear in the snap of a finger. Again, the responsible person concept, it's very important that you get in there. And I mean, this one had risk manager, manager, foreman, or supervisor of an insured responsible for any health or safety affairs. That's going to include any foreman or supervisor on the construction project, right? That person is going to be charged. The company is going to be charged with that person's knowledge. So if they try to deal with something at the project level, process that owner's email and deal with the issue themselves, without getting everybody involved, that's going to count for that reporting obligation. One quick slide on pollution. It's the counterpart to the pollution exclusion, which is very broad itself. So the coverage itself here is very broad. It's not going to be limited to traditional environmental pollution. We're not just talking about spills of toxic materials and things like that. These three examples in the bullets are real claims where we actually got coverage. I like to use one where our contractor was doing a cut and cover tunnel subway extension in LA, right next to a popular conference hotel in downtown LA. They brought a $25 million takings claim and a $250,000 property damage claim for construction dust that got on the furniture in the lobby, and they had to incur a lot of cleaning costs. That $250,000 property damage claim got the contractor a full defense from the pollution insurer for the entire dispute. $25 million takings claim and all. So really broad, useful coverage for anything that's an irritation, that's a smell, that's a sound, or something like that is disrupting and causing somebody to make a claim about something. Check out pollution. It is also often claims made coverage. So the same rigid reporting I just talked about with the other policies, true here too. And then again, construction companies are just like every other company. They've got all the same risks plus all the stuff that we just talked about. So all these other things are true as well. I want to plug that CyberGuard in there now because there's a actually construction specific cyber program out there, which has never been the case until very recently. All of these can give rise to issues, but they're not going to be terribly unique to construction. And that's all. That was rapid fire on the last few slides. So if anybody wants to talk about any of those, feel free to give me a call or about anything else at really any time. Happy to.
Thank you, Will. Really
Yeah.
appreciate that. You wrapping up right at the hour, on the dot. If you got another 2 or 3 minutes, we have one more question in the chat. But thank you, everyone. Don't feel the need to stay past the hour. We do try to keep these things budgeted. But
Yeah,
as
let's
to
do it.
this other question is coming back to additional insurance onto the CGL. Question kind of concerns whether, there's the your work exclusion under a CGL policy. If you're dealing with additional insurance, um, is damage to the general contractor's other work your work? If it's not, whose your work is it on an additional insured policy basis? Is it that sub's work who is the primary insured? Is it the claiming insured's work who's the additional insured? How does that work?
Yeah, so um, that's a really interesting question. That's a really good question. So the CGL policy, right on actually I'll go back to the right slide for this. Give me a second. So it'll be helpful to look at it. The CGL policy starts right out of the gate with this paragraph that says throughout this policy, the words you and your refer to the named insured in the declarations and any other person qualifying as a named insured. Somebody who is an additional insured is not a named insured. So they are not you or your within the meaning of that paragraph. The interesting thing is then the definition of your work then uses, which is itself, defined and would suggest that maybe it could mean something else. The definition itself then uses you and your in it as well. So the implication is that your work, and I think most jurisdictions will follow this, typically refers to the work of the named insured only. And that underscores a broader important thing to keep in mind, which is when you're evaluating the coverage available to an additional insured, you need to pay careful attention to the use of the words you and your in a few particular spots to understand what coverage is available to the additional insured and how it differs. And in particular, that's relevant in the contractual liability exclusion. So if you just read it without thinking about that distinction, you'd think, okay, the additional insured has that same coverage for contractual indemnity obligations that the named insured has. It probably doesn't because of the use of the words you and your, only referring to the named insured. The other one that's really a sneaky issue that I think most people don't, even the general contractors at the top of the market don't understand. Exclusion L to the policy, which is like the exclusion that's usually relevant when you're self-performing work. So the exclusion says we don't cover property damage to your work arising out of it or any part of it and included in the product's completed operations hazard. So we don't cover property damage to your completed work, which would be construction defect claims, right? Except that there's an exception that says this exclusion does not apply if the damaged work arises out of work that was performed on your behalf by a subcontractor. Okay, so the general contractors, I think, are generally thinking, all right, well, the work was performed on our behalf by a subcontractor, so we're good. Except if they're an additional insured, the exception says performed on your behalf by a subcontractor. So arguably that exception only applies to the named insured, which if you play that out to its logical conclusion,
Yeah.
and this has played out in case law in some states, the general contractor actually, without a policy modification to the sub's insurance, can't get additional insured coverage for construction defect through its subs policies, even
Wow.
if it's named as an additional insured. And that has caught a fair number of general contractors by significant surprise.
Wow.
Yeah, so keep that in
Okay.
mind.
Well, thank you.
Hopefully, I
Appreciate
answered
it.
that question. I don't even know. I went off
I,
a tangent there.
I think you did. You went
Yeah.
off and went well beyond. I think we've addressed all the questions in the chat. Thank you so much, everyone. Reminder: our next nuts and bolts is July 16th. You'll see an email. Thank you, everyone. Appreciate it.
Thanks,
Thank
Saka.
you, Will.
Yep.
Thanks.